All right, good morning, everyone. We can go ahead and get started. Thanks, everyone, for joining. My name is Meg Corcoran. I'm president of the Law Alumni Association School Group this year. And we thank everybody for joining us on a Friday morning. We'd like to give a quick thank you to our sponsors, AXA Advisors, Chicago Title, Council Press, Fine Law, Jack W. Hunt and Associates, and Precision Resolution Paramount Settlement Planning. They help us be able to offer some of these programs to you, our alumni group. This is one of a series of free CLE program that we're offering to the Law Alumni Association related to COVID-19 topics free of charge. We also have a couple coming up on June 30th, Walking an Ethical Tightrope, How to Protect Yourself in Court When You Disagree with Your Client, and July 10th, which is Business Disputes in Bankruptcy Court in the Era of COVID-19. Those will both be free CLE programming for any UB alumni. This is in addition to the other CLE program we provide to our paid members every year. So if you're not a part of the Law Alumni Association, I'd encourage you to join, because that is one of the perks that we give our members in addition to other research tools that you can use as a paid member of the Law Alumni Association. A couple housekeeping items before we get started. So the audience is going to be muted. If you have a question throughout the program, please submit it into the chat function. You can find it at the bottom of your screen when you toggle over your Zoom page. I'll be monitoring that box and trying to pose those questions to Natalie throughout the program. Also, sometime during the CLE, we are going to announce the course code. You'll need this to put on your CLE form that you return to Pat Warrington. I'll announce it, and then we'll also put it in the chat box function as well. So you keep an eye out for that. And just remember that you'll need to return both your CLE form and your program evaluation form to get credit. I'd like to thank Natalie Ermacher for joining us today and presenting on this topic. Natalie is a UB Law graduate from the class of 2013. She also holds a BA in Spanish and History from St. John Fisher College. Ms. Ermacher serves as senior counsel at Malik and Popio in Buffalo, New York's office, where she works with a variety of businesses to prepare and submit employment-based non-immigrant petitions for employees in the H-1B, E-3, TN, and R-1 categories. In addition, Ms. Ermacher assists with permanent resident green card filings involving perm labor certification, religious workers, and national interest waivers. Ms. Ermacher has extensive experience with family-based immigration petitions via consular processing and adjustment of status, as well as K-1 fiance and naturalization filings. Natalie, thanks for agreeing to present, and I'll hand it over to you.
You're welcome. Thanks, Meg. Good morning, everybody, and happy Friday. Thanks for joining me today. The topic Meg kind of alluded to, impact of COVID-19 on U.S. immigration. Our practice focuses on family and employment-based immigration, so I'm kind of focusing this talk on those two aspects. There's a lot that's happened in the last few months, so it's also ever evolving and things are changing as we start to open back up. So do offices around the world, consular offices, embassies. So it's really impacting how our clients and all immigration clients have access to the benefits they're seeking. To begin, because there's a variety of people at different stages in their legal careers, I just wanted to go over quickly the kind of parties involved in any immigration case. So it varies between what type of application you're filing, but the main parties that will be in the cases that we kind of process are the Department of Labor. The Department of Labor is the one that ensures U.S. workers are not being displaced by hiring foreign workers. In two different aspects, they're involved in an H-1B specialty occupation and E-3s for Australian nationals. They are the ones that affirm that the sponsoring U.S. employer is going to pay the prevailing wage. So any H-1B worker or E-3 worker that wants to come here has to be at or above the prevailing wage. The Department of Labor, you have to file what's known as a labor condition application for these positions, which indicates for that county and that location, the person's earning what they should. They're the ones that verify that. So the LCA, labor condition application, is a necessary step in any of those processes I mentioned. They also are the ones that process perm labor certifications. So when employers seek to sponsor someone for permanent employment, this is the first step of that process. They also are required to affirm that the employer is going to pay the prevailing wage again. The other also big entity is USCIS, U.S. Citizenship and Immigration Services. This is the entity where you apply for non-immigrant and immigrant visa classifications, usually for people who are inside the U.S. The USCIS is the person that will make determinations on, for instance, an H-1B position is a specialty occupation, which is required under regulation. They also are the entity that will determine if a person is eligible for the classification they're seeking. Another player is the U.S. Department of State. The DOS actually has a lot of different functions in a lot of different categories, but typically they are the ones that they allocate the immigrant visa numbers. So these vary based on designated regions and employment-based and family-based categories. So they're the ones that kind of determine if you're eligible, again, for the classification you seek. The NVC, National Visa Center, this is another entity which actually processes consular cases. So once an application is filed by USCIS, for instance, or to USCIS, they approve the petition. But if the person is outside the United States, the USCIS will then forward the case to the National Visa Center. And they are the ones will then make all the determinations, such as this person has a police clearance certificate from the countries they've lived in, they meet all the other criteria, and then they allow them to go to the consulate to process for whatever visa stamp is necessary. And then one other entity I didn't actually put on the slide is obviously CBP, which is Customs and Border Protection. They're obviously involved in the processing of border cases. So whenever someone seeks, for instance, a TN under NAFTA, they will go to a CBP officer and they'll adjudicate it right at the border, whether or not the person can be admitted in TN status, among other statuses. For right now, regarding CBP, I just wanted to make a quick mention that they've actually suspended their trusted traveler program. So a lot of employees, foreign employees that are working here, Canadian employees, they have like these passes that allow them to pass through the border more quickly. All those programs were suspended at the onset of the COVID-19 pandemic. Also, just some quick terminology in case people aren't aware. A lot of people will say, I have an H-1B visa, I have a TN visa. That's kind of a misunderstanding of the term. So a visa is just a stamp in your passport. It's a boarding pass almost. So it allows people to actually enter the U.S. It doesn't give you status. So status, the one below, is the actual category that someone enters into the United States. So if you have H-1B status through December 2020, that is the period you are allowed to remain in the U.S. So very different terms. A visa is a boarding pass. It doesn't give you status. Status is what allows you to stay and work in the United States, depending on your category. Another term that we use also is adjustment of status. This is the process of applying for a green card from inside the United States. So an adjustment of status is when you are adjusting from a non-immigrant category to an immigrant category. So you are becoming a green card holder, a permanent resident, lawful permanent resident. A change of status, on the other hand, is when you change from one non-immigrant category to another non-immigrant category. So for instance, you are an F1 student right now, but you seek to start working in H-1B status and you're applying through the quota. I can talk about that later. You're going from F1 to H-1B, so that's a change of status. It's different than adjustment. So that's also something that also gets a little confused. Consular processing. You can process for a green card while outside the United States. That's when the NVC is involved, National Visa Center. So consular processing is just a different method of obtaining a green card or other non-immigrant category. Premium processing is the ability of a client or, excuse me, an applicant or a petitioner to pay an additional $1,440 to USCIS, and USCIS will process their case in 15 calendar days. I know my boss likes to call it a bribe, a legal bribe, but that's very common nowadays. People just want to know that their applications are secure and approved, and there's a lot of heightened anxiety under this administration. So it's something that is very coveted. Okay, so to begin, the challenges that we face and that a lot of non-immigrant aliens or non-immigrants have faced is the closure of the northern and southern borders. Way back in March 20th, Department of Health and Human Services issued a rule that they were going to close the northern and southern borders to non-essential travel. They invoked this public health statute, which is on your screen, that permits the Surgeon General to suspend entry from anyone deemed to be a serious danger of introducing a communicable disease. Essential travel is kind of detailed below on this slide, but usually it's typically open for all types of commerce. As you know, they haven't closed it for food deliveries and things of that sort. They've also kept it open for healthcare workers. I know TNs for pharmacists have been approved at the border, so it's kind of touch and go, right? It depends on which border you go to, whether or not they're going to be processing cases. But for the most part, these are the essential travel that hasn't been suspended as of yet. Their borders have been and will remain closed until at least June 21st. There has been rumblings that they're even going to extend it to the end of July. So I don't think that's been made official yet, but that is what it's looking like. It seems that Canada is also starting to open the border to immediate relatives of Canadian citizens and permanent residents, as long as they remain there for 2 weeks. And then, as on the screen, immediate relatives include spouses, common law partners, dependent children, parents, and guardians.
Natalie, one question that came in is essential travel. So I know you mentioned as examples some healthcare workers and within that paragraph. Is that tied to what is deemed an essential business as well?
So you mean an essential business in the U.S.?
I think so. I think it's by state.
Yeah. So, I guess you can make that argument to a CBP officer saying that you work an essential role in the U.S. and you need to enter. Every CBP officer has a very wide array of discretion. So, we see people that process sometimes very easily through the border, and then some people will get denied or turned around pretty quickly based on the same documentation. So is that something that definitely would help, make your case at the border? I think so. Is it necessarily intertwined? I don't believe they do relate in that sense. But I think, as I said, it's a discretionary process every time you enter the border. So it could help. Also, President Trump made several proclamations over the last few months banning entry of anybody entering from these regions if they've been there for the past 14 days. China, Iran, the European Schengen area, which encompasses all of these places, United Kingdom, Republic of Iran, oh, I have that twice, I'm sorry, and Brazil. The challenge here also is not only are these people not able to enter the U.S., there's also bans across Europe from them entering any of these other European countries. So every country has their own travel restrictions right now. And I actually had someone call me saying that they wanted their K1 fiance to come to the U.S. for a visit, and she had documentation that she had, had a negative COVID-19 test, and she had a letter, I think, from the embassy, things like, all these things she thought she needed. And before even getting to the U.S., she was stopped in Germany and turned around. So, things like that are happening all over the country and all over the world. So we have to kind of be cognizant of the fact that everyone's, again, heightened anxiety, not only about this administration, but also COVID-19 and the challenges it presents. So there was also another presidential proclamation that was banning permanent residents from coming in. So these were people who have approved immigrant petitions but have not yet entered the United States. How it works typically is your application is approved and you get an immigrant visa stamp at a consulate, which allows you to enter. And then once you enter, you get a green card in the mail. So these are for people that are processing from outside the U.S. The presidential proclamation relating to this was saying that people that have these approved applications but haven't come in yet, well, we're going to suspend you from coming in for another 60 days. That was on April 23rd. So that's at least bringing us through the end of July, when these people who've waited probably years and years to get their green cards finally have the opportunity, and all the borders are closed and we're not allowing you to enter. So that creates unique challenges as well, because typically once your green card application from outside the U.S. is approved, you get 6 months to enter. So the immigrant visa stamp, your boarding pass that allows you to enter the United States, will only be valid for 6 months. So if within this period you can't travel, your 6 months expires, what do? There have been kind of rumblings that although consular officers are not allowed to extend that period, because it's 6 months is a regulatory period, they may be able to reprint the visa foil, which is basically the stamp. So hopefully it will allow people to enter that were barred from previously. There were specific exemptions to this, which are listed on the screen, but aliens seeking an immigrant visa as a physician, nurse, or other healthcare professional, they were allowed to enter, which thankfully, that's a good thing. And then obviously people performing medical research related to COVID-19 and other essential work relating. It's not necessarily defined there, but it's a good thing. And then on May 5, 2020, this isn't an actual law yet, but the Healthcare Workforce Resilience Act was introduced to Congress, and it would seek to use a bunch of unused immigrant visas between the period of 1992 and 2020, which, believe it or not, there's thousands, for doctors and nurses to provide expedited processing for them to enter as green card holders. One other category that has been affected is the visa waiver program. So this program allows citizens of participating countries to enter the U.S. for tourism for up to 90 days. They are non-extendable. So basically, once you come, you're supposed to leave when your status is up. But because of ports of entry being closed, deferred inspection sites being closed, and other travel restrictions, people admitted pursuant to the visa waiver program have overstayed that 90-day period. So it's been issued. They've said that now people can apply for what's known as satisfactory departure. It's like a 30-day extension that says even though you didn't leave on time, we're going to give you an extra 30 days. And then they are also allowing subsequent periods of satisfactory departure. You make these requests at a CBP point of entry, so you could go to the Peace Bridge, Lewiston, any of these places, and typically they should be extending your status based on this. There's also usually a requirement that you go to the same POE, point of entry, that you actually were initially admitted to, but they've kind of suspended that requirement as well. One other thing to mention that's actually not on, or I did actually add it. So other visa categories are also kind of stuck in the U.S. So say you came in as a B1, B2 visitor and your status expired. Typically you start to accrue unlawful presence. But right now there's, what do you do? What do you do if your status expires and you can't go home because they're not letting anybody enter? There have been a few instances in our practice where we've had to request either a change of status to B2 because their other status expired, or just an extension of B1, B2 because people can't leave. Under this regulation, you can, USCIS will excuse a late filing, meaning you let your status expire and you're filing late typically you request an extension before your status expires, but they'll excuse a late filing if these 4 criteria are met. The delay was due to extraordinary circumstances and that were beyond the control of the applicant, and the delay is commensurate with the circumstances. So in this instance, you know, border closures and, you know, travel bans, these are all extraordinary circumstances. So this is kind of the most favorable environment to file for this type of discretionary relief, as long as these other 3 categories are met. The alien has not otherwise violated non-immigrant status, they remain a bona fide non-immigrant, and they're not subject to removal or deportation. So this is kind of a remedy if any of your clients, you know, have kind of let their status expire because they didn't know what to do. We filed a couple. I mean, they're pending process, but, you know, we're hopeful that they will process smoothly.
Natalie, one question that came in, are you seeing in terms of the time frame for processing, do you have any idea as to what that turnaround might be once the petition is filed?
Yeah, so that's the golden question. Sometimes, you know, you'll see processing, for instance, it depends on the visa, on the category, number one, but we've seen processing of H-1B petitions in like 6 to 8 weeks, which is like unheard of, right? If they're not filed in premium, that's kind of unheard of to have it that quickly. Other kinds of filings, like K-1s for fiancés, because all of the consulates are closed and they're not accepting visa interviews, all these things are taking longer. So typically, you know, I can't give an exact date because that also varies by service center, where you submit your application. But we are seeing that they are kind of quickening up the pace because I think they don't want to get as backlogged. I mean, they're already backlogged, right? All the adjudicating agencies. But I think they're trying to process them as they come. I know that's not really an answer, but that's the best I can do. I don't have a definite one for you. H-1B specialty occupations. Okay, so H-1B petitions are for non-immigrant. It's a non-immigrant category that has dual intent. So you can enter as an H-1B, but later become a permanent resident if you have, for instance, a sponsoring employer. But it's an employment category that's specific to individuals who hold bachelor's degrees or higher, and the positions have to be what are considered a specialty occupation, which is defined by regulation. Every year there are 85,000 spots allotted during an H-1B quota period. 60,000 are for people with bachelor's degrees, and then another 20,000 for people with master's degrees. This year was kind of crazy because they changed the process. Usually we would apply for someone's H-1B visa, H-1B status for within a 1-week period. So the quota opened April 1st usually, and it would only extend through like April 5th. And all of the petitions would have to be submitted. So USCIS would be receiving thousands and thousands of petitions, and it's usually more than are allotted. So there's 85,000 spots, but like 220,000 would apply. So they conduct a random lottery, and then whoever is selected in the lottery, then they can continue processing their cases. This year, they, for whatever reason, changed the process. So there was a registration first, and then before you prepared the petitions and submitted them, you actually knew ahead of time if you were selected or not. So this period, and then in addition to that, once the registration process was over and you knew if you were selected, you get an extra, you get 90 days to file. So really all of the H-1B petitions this year for initial H-1Bs are due at the end of this month, which is like unheard of, right? We're used to just like doing hundreds of cases in March and then submitting them in April and being done. It's a big change in how how they're doing it. So for right now, I mean, we don't know how good it's going to work. There were some glitches in the beginning, but that's kind of the situation now. H-1B holders are permitted 6 years in H-1B status. At that point, if your employer wants to employ you long-term, they have to begin the permanent residency process at least a year before, because the perm labor certification process takes months and months to complete. There's posting requirements to notify U.S. workers that you're hiring a foreign worker, and all these different processes. So that's the 6 years you get. So on top of all these people applying for their initial H's, you have people within that 6 years that are here already working, that need extensions on their H-1Bs, that maybe they're changing employers, going to a different H-1B employer. So it's a constant kind of thing. You have to keep up with your status and always know when you're expiring so you don't fall out of status. The Department of Labor requires U.S. workers to, requires employers to notify U.S. workers that they're hiring an alien. So there's posting requirements. Once that initial labor condition application is filed with the Department of Labor, employers are required to post that LCA in 2 conspicuous locations for at least 10 days. So the idea and the purpose behind that is to notify these U.S. workers. Well, given COVID-19 situations, there's all these stay-at-home orders. So you're posting these LCAs, but there's no one there to see them. So are you in compliance with the regulations when you do that? So on top of layoffs, furloughs, stay-at-home orders, there's been a ton of economic repercussions for H-1B employers and beneficiaries. So the stay-at-home orders, working from home is generally permitted in H-1B filings, but you would usually in the beginning have to include that person's home address in the labor condition application. When it happens in the middle of a period, say you have an approved H-1B petition, for 3 years, and this is happening after year 1, you can't go back and change your LCA, right? Because the petition's already been approved. So there's a couple different remedies for this, which I detail below. There was a decision in matter of Simeo that said if you are changing to another work location within the same metropolitan statistical area that the LCA was filed for, you don't have to file a new LCA and you don't have to file an amendment, because basically you're still in the same area, you're still earning the same prevailing wage that's required. So you just have to repost the LCA basically in the new location. If the employee's home is outside so that would be covered. So if someone had to go home, but they work close to where their work address is, that should be covered by that. If the employee's home is outside the MSA, there is another kind of ability for a short-term placement provision. So if they're allowed to work somewhere else for up to 6 weeks. And then if quarantine lasts longer than 30 days, they would probably need to file a new LCA to cover the new residence that they're working from. So, we're doing our best to kind of mitigate how much an employer, because every H-1B petition comes at significant cost to an employer. There's USCIS filing fees, there's legal fees, and then, obviously the cost of moving. So if someone has to go to a new location to start their work, there's, just a lot of financial costs involved. So the other issue is the prevailing wages. So because of all these different things that are happening, a lot of people are getting reduced hours. That's really not allowed. You can't just reduce an H-1B employee's hours in the middle of their approved petition period, validity period. So they kind of have to reassess what's going on with their businesses, and sometimes we've seen layoffs occur, reduced hours, all these types of things, just so that these businesses can stay afloat. The challenge is not letting them fall into non-productive status. A lot of H-1B employees, a lot of our clients are in the IT field. So usually they're hired for a period of time to complete a project. Well, if due to COVID-19 the project's been suspended because the company just can't, pay for all of the resources for it, these people are out of work because their jobs are basically pursuant to a work order or a statement of work for a period of time. So, even if they fall into what's called non-productive status, employers are still required to pay them their wages. So this is what leads to people being laid off, or employers withdrawing their H-1B petitions, which is very unfortunate. So there's kind of like a little caveat here. If the employee is in a non-productive status due to a decision of the employer, say they said they have to lay the person off, they do remain obligated to pay their wage. If the person's in a non-productive status because of what the employee is requesting, based on, there's things here, voluntary travel, maternity leave, these things, the H-1B employer is not required to pay the offered wage. So a question we've seen from our clients is, can the employer bench or otherwise render an employee non-productive and stop paying the offered wage? When, like, for instance, they're in a position where they're unable to work from home. They work in a factory, different, plant managers, things like that. They can't work from their home. Benching employees is never okay. So it's not permitted in this circumstances because the situation wasn't created by the employer. Otherwise the employer would be liable for fines, back wage obligations, and barred from filing immigrant or non-immigrant filings again if they did decide to bench the employee. Is the employer required to pay the offered wage if the employee contracts COVID-19 and is unable to work? Unfortunately, the answer to that is maybe. Regulations don't require an employer to pay the wage if the employee is not able to work due to reasons not work-related. Contracting an illness is not necessarily work-related. However, an argument can be made that the employer's policies of a stay-at-home order are the ones that are causing the non-productive status, and therefore it's an employer policy, so they should be required to pay the offered wage. If at some point the employer says, you know what, I can't do this anymore, I can't maintain this person's wage, I have to fire them, they're required to pay a reasonable amount of money for the person to return to their home countries, which again, who knows if they can, but that is in regulation. And then if someone seeks to convert to a full-time employee to part-time to salvage their position, usually that would constitute a material change to the petition, and an amendment would need to be filed with USCIS. So before I start talking about permanent residency cases, I do also want to mention, while we're still talking about H-1Bs, for all these H-1B extensions or amendments that we have to file consistently for all of our clients, there are usually, I shouldn't say usually, there are sometimes requests for evidence issued by USCIS. So USCIS will say, I don't believe this is a specialty occupation, give us more evidence of that. So typically you would get 3 months to establish to respond to an RFE. But since the onset of COVID-19, they've actually become a little bit more lenient, thankfully, and there's a 60-day extension. So for certain filings, for those responses, we're getting an extra 60 days to respond from that due date. Additionally, there was a suspension of premium processing, which is that expedited service. They have now started to reinstate that. So these are just kind of things that are ongoing, but they're doing it in phases, premium processing. So initially they're going to start doing them for certain types of cases, but as time goes on through June, they're opening it up to the rest of the categories that qualify for it. Okay. Employment-based permanent residency filings. These consist of 3 steps. The first is that perm labor certification we were talking about earlier. The second is an I-140 petition, and the third is the actual green card application, the I-485. So relating to COVID-19, the filing of a perm and subsequent I-140 petition will allow an H-1B worker to renew their H-1B status beyond those initial 6 years they get. So once you clear that hurdle of that second step of the green card, the I-140 petition, you're allowed to just keep renewing your H-1B until you get your green card. For some people from countries where there are backlogs, this could be like 10 years of H-1B status or even longer, just because there were so many more applications for immigrant visas than are allotted for that country that they have to wait for the visa number to become available again. That's also governed by the Department of State and what's called the Visa Bulletin. So backtracking a little, the perm, as we discussed before, they require that prior to the filing of the perm, the employer must notify the workforce that it seeks to fill this vacancy with a foreign national. Notice of filing must be physically placed at the worksite where the beneficiary will be employed, and it must be placed in any and all in-house media, and the employer normally must recruit. So there's a lot of different requirements for posting this notice of hiring this individual that are required, and they have to be posted for a certain period of time. But again, there's that unique challenge of, well, if you're posting it, who's going to see it? If possible, the kind of resolution to this is, if possible, wait until the quarantine ends for you to post the notice. That's a kind of an easy fix if it's possible. If waiting is not possible, post notice at a work site and provide additional notice to employees working from home. So send an email, send a direct mailing to them. These types of things are not typically, used, but in this environment, kind of you have to adapt to satisfy those requirements. Also, the DL's Office of Foreign Labor Certification, OFLC, has started emailing PERMs. So once you apply for this PERM labor certification, the DOL will either certify it, issue an audit, or deny it. But the ones that are certified would typically arrive to our office in this like fancy blue paper. It's thick. It's it's a specific type of paper they use, and you can only use those original copies if you wanted to file for that premium processing, for that expedited service. Well, because we've been emailing them due to COVID-19, that kind of eliminates that ability for people who actually need the I-140. So, as I said, you have to clear that I-140. You have to get that approved in order to renew your H beyond the 6 years, your H-1B. But if you can't file in premium, say you need it, your H is expiring in a month, and your PERM is certified, but you can't file your I-140 in premium because you don't have those original blue papers. That causes an issue for people because they could fall out of status or they don't have a basis to extend their status. We have seen recently on discussion boards with other immigration attorneys that they are accepting premium for these cases recently, but it kind of was up in the air because it created a lot of issues for people. So that was, one other issue that we encountered. And then there was also this issue of public charge considerations. So in February of this year, there was a final rule regarding the public charge ground of inadmissibility. Basically, under this administration, it's become much more challenging to even have a family sponsor an individual to come in, their parent, their spouse or fiance. They've instituted this additional kind of vetting to determine if someone is going to become a public charge upon admittance. Now, this was also always part of the process. There's something called an affidavit of support that a sponsor would have to, for a family-based case, would have to complete, saying if this person enters, I am financially responsible for them. They are not going to become a public charge. That's always been a requirement. Now there's an additional kind of form that now requires proof of your credit score, proof of health insurance, proof that you filed tax returns in the past. That was also always a part for a financial sponsor, but this is for other people as well now. So it's become challenging because a lot of people, for instance, if you're sponsoring your mother and they're outside, they've been here, but they're 85 years old, they don't have a credit score, they don't really, they've never established this type of evidence that USCIS is seeking. So that's been a change. And now anybody who wants to extend or change their status, even non-immigrant petitions, they have to show this financial independence as well. It's a condition of approval. There's also this public benefits rule. So if you've been receiving any type of public benefits for more than 12 months in total within any 36-month period, you could be deemed inadmissible on public charge grounds. But, all these people are losing their jobs, and, they might have to rely on different types of public assistance. So it also, for these beneficiaries, it creates a unique situation for them because they have to work, but they can't. But they also can't get public benefits because they could be deemed inadmissible. USCIS did indicate that it would not consider testing, treatment, and preventative care, including vaccines relating to COVID-19, as part of its public charge determination, which was, nice, threw him a bone. And then, it's also not applicable to certain immigrants seeking an extension or change of status, even if it's paid for by a public benefit. Checking my time quickly. Okay, I think we have a little bit more. Will obtaining unemployment insurance impact my client's immigration application under the public charge rule? So unemployment insurance is generally not taken into consideration when determining a public charge determination, because those are considered earned benefits through the person's employment, and also tax deductions. So that you should be okay there. Who is eligible for unemployment insurance? Under the Federal Employment Tax Act, foreign nationals typically qualify for regular unemployment benefits if they are authorized to work. So authorized to work is a term of art. It kind of will vary from state to state. So there's an example below. If each state is different in how it handles it, some states limit eligibility to permanent residents only. Others require the unemployed individual to be established they are able to work, available to work, and actively looking for work. So many non-immigrants, such as H-1Bs and L-1s, they're only authorized to work for a single employer. So if that job goes away, they're not necessarily able to work or available to work, because those types of classifications are employer specific. So, that's kind of the challenge there. So people who are employed to employment authorization documents, these include spouses of H-1B workers. They can work wherever they want. So there's no requirement that they work for a specific employer or at a specific location, as there is for an H-1B holder. So these people actually would be considered available to work and able to work. So therefore, they may qualify. Undocumented workers, they cannot collect unemployment insurance, and they were not authorized to work during the designated period, so they cannot demonstrate that they are available to work. We have seen this a few times with our clients. Will receiving a recovery rebate under the CARES Act impact my client's application as a public charge rule? No. So the short answer is no. Issuance of a one-time recovery rebate is structured as a advanced tax credit to be dispersed by the Treasury Department. So the final rule on inadmissibility, it won't take that into account. Right now, all of the forms that we have to submit to USCIS have this section relating to the public charge rule that specifically asks every beneficiary, have you received any of these types of benefits? If so, how long did you receive them? Because they're trying right away to vet out all those people that have received any type of benefits and deem them inadmissible. So this was something that was never a question before until this year. This is kind of who is eligible for the rebate. Only individuals with valid social security numbers and people who qualify as resident aliens are defined by the IRS are eligible for the rebate. Non-U.S. citizens are considered non-resident aliens unless they meet one of these two tests. These are actually tests established by the IRS. The green card test, that's an easy one. Are you a green card holder? And then the second one is substantial present test. To meet this test, an individual must have been physically present in the U.S. for a designated minimum threshold period as outlined by the IRS. So for these categories that are listed below, they exempt these statuses from the physical presence calculation. They are not exempted, may be able to meet the substantial presence test. People who, the last point there is a lot of individuals who don't have a social security number yet because they've never been issued a type of employment document that would allow them to apply for one. They will sometimes be granted an I-10 number, which allows them to still file taxes. Those people, they're ineligible, unfortunately. Okay, so that's it for me for right now. I wanted to open it up to questions. If there's anything specific somebody wants to ask me, I think now's the time.
Just as a reminder to everybody, I put the course code in the chat box, but the course code is BORDER, BORDER. Okay. I'm not seeing any other questions coming in, Natalie, for right now.
Okay.
Natalie's contact information is up on this screen, so of course you could always contact her after the fact. I know some people were shooting their questions just to me. So I tried to get those to you during the program, but thank you for presenting. Do you have a question? Are the PowerPoint slides available? They will be made available on the UB Law Alumni Association's website. Oh, one question did just come in. Do you have any early sense of the entry to Canada by US citizens with property in Canada?
So, you know, considering that's non-essential travel, and every indication is kind of looking like they're going to be extending the closure until July. I would say at the earliest, end of July. Beyond that, they really haven't given any more definitive answers. But yeah, that's anticipated is that it's going to be extended till the end of July at least.
Got it. Well, thanks everyone for joining. And yes, the slides will be made available, and you can certainly contact Natalie, Senior Counsel at Malik and Popil. If you have any follow-up questions, just a reminder to use that course code border and your CLE form and return that in your evaluation form to Pat Warrington. We do have a couple other CLEs coming up as a reminder. So June 30th, walking an ethical tightrope, how to protect yourself in court when you disagree with your client, and July 10th, business disputes in bankruptcy court in the era of COVID-19. So those are both 1 hour CLEs, free to all UB Law alumni. Thanks again to our sponsors that we mentioned at the beginning, AXA Advisors, Chicago Title, Council Press, FindLaw, Jack W. Hunt and Associates, and Precision Resolution. Without their support, we wouldn't be able to put these on. You'll notice that they're in the chat function right now. There is a URL. So if you want the slides, they'll be posting them soon on law.buffalo.edu/alumni. And thanks again, everybody, for joining. Have a good weekend. And Natalie, thanks again for presenting. It was awesome.
You're welcome. It was my pleasure. And anybody who wants to contact me, please, feel free to send me an email or give me a call. Thank you.
Thanks, guys. The course evaluation should be submitted back to Pat Warrington. I believe it was in the email that had the URL link. Pat, are you still on?
Yes, it's our website, law.buffalo.edu/alumni event.
Right. Who do they submit the evaluation forms to?
They also, mooring@buffalo.edu.
Yep. So submit them to Pat. I will put her email right in the chat function. It should be the same email that you received the Zoom link for the program. You can return your evaluation forms and the CLE form with the course code to that email. Thanks, everybody.